DK, your best wingman. Grow with DK. Searching for world mediator deacons. Interview with George Lem.
Hello, Assalamualaikum, Selamat Patang, Namaste, Namaste, 大家好, konbanwa, habari, omani batem, 안녕하십니까. Welcome. First episode of World Mediation Decons. This is DK. I'm so excited to have my guest today. His name is George. If you need to choose one mediator in Asia, he is the one. Hi, George. Welcome to the show. Could you introduce yourself?
Sure. Thank you, DK, for that introduction. I'm not sure I can live up to that expectation, but I always pride myself to try and do my best at any mediation. So I'm George. Just a bit of background about myself. I've been in legal practice for 40 years in Singapore. I'm a senior counsel, and I started mediating 25 years ago. So now I do this. 8 years ago, I decided to do this full-time. Used to be a litigator, arbitrator, but now I'm a full-time commercial mediator, and I do about an average of 1 or 2 cases a week.
And your wife loves Korean drama, and your son graduated Seoul National University master's degree.
Yes. So my son did a very unusual thing. He did his master's at Seoul National University because I think when he was in university, he did an exchange program at Busan,
Wow.
Busan University, and he liked Korea. My wife, yes, watches Korean drama like many other Singaporeans, and I do as well.
That's great.
Yeah, we have a lot to learn from. We have a lot to learn from your culture and your history.
Thank you so much. And as you mentioned, you have a 40 years career and you started full-time mediator 8 years ago. And could you tell me the reason for you becoming full-time mediator?
Yeah, so when I became a lawyer 40 years ago, I took an oath, like many of us did. And one of the things we promised to try and do is to serve our clients in the best way, to act in the best interest of the clients at any time. And if it means helping a client resolve a problem quickly, I think that's part of our ethical duty. So I tried to follow that in my career as a lawyer, to make sure that law is a service. We all want to make some money, yes, that's fine. But I think at the end, it is a service. It's a very serious thing because clients come to us, they entrust their faith in us, sometimes their liberty or their lives. And I think it's a real privilege to be a lawyer. So for me, I've tried to follow that. I think sometimes you succeed, sometimes you don't. But the only way we were told or we were taught to resolve a case is through litigation or arbitration for many years. But when I went to do my mediation course in 1996, I did it in England and in Harvard. I discovered there's another way to resolve a matter. And I got persuaded, I got converted by mediation. So I did mediation on the sidelines. Yeah, I was still a litigator, arbitrator, and then I would do mediations. And I found that it is so much better when you can help parties resolve disputes themselves. They take ownership of the problem, they take ownership of the solution. And I had many cases where people shook hands at the end on. And something which you couldn't do in court. Even you win, somebody else loses. So in a mediation, everybody tries to get something out of it. I've done many mediations where even family members who have a dispute, they may come up to that. It takes a while, but a bit of healing. So for me, at the back of my mind, it was something which I would like to do in my age. So when I approached 60, that was about 70 years ago, before I reached 60, okay, in my late 50s, I decided I wanted to do a change, yeah. And I find a lot more satisfaction doing mediation, so I said, yeah, why not? So I took the bold step to go full-time. And I've not looked back because it's really been a fulfilling journey.
So I heard that your money generated by mediation is not less than the litigation or arbitration, and that's because of your career as fully grown-up lawyer. So if you were as middle-aged or juniors, then full-time mediator is so much hard job for them. Do you agree with that or not?
No, so for me, mediation should be a proper profession. we should take it seriously as mediators. We should try and add as much value as possible, and people should pay us for that. So when I took on mediation, I decided that I would charge my senior counsel rates. It's of course less because it's shorter, 1 day, 2 days, maybe 3 days at most, like a litigation which goes on for years. So it's still a big discount for parties when they come to me. But I charge the same hourly rate because for me, I'm confident that I can add value. In fact, if we settle, I save the parties, both sides, so much time and money. It's sometimes you just need that third party to help parties move towards that outcome. And I think we add value in that way. So I said, why should I shortchange myself? But the other thing is also for me, I wanted to set that standard for Singapore to tell people that this is not just a retirement job. If you're a good senior lawyer, you should do this as well because you can still earn it. Otherwise, mediation will be left to people who just do it as a pastime or retirees. And for me, there must be money in the game as well for people to respect it and for people to see the value.
What's your best memory and worst memory as mediator? Can you share any episode?
I can share many episodes. I'm not sure you have the time. Very quickly, I did one case involving a young boy who was involved in a personal accident, who lost his leg, and he actually wanted to commit suicide. But because of the mediation, we resolved it very quickly, and I think we helped his family. And that was, for me, was so much better because I told the lawyers, don't make the boy go through 2 or 3 years of litigation to get his money. He's already gone through so much. And the lawyers responded very positively. I had another case, 3 friends who were in a joint venture, fell out, sued each other, came to me before a mediation, and we resolved it. And that was just before the Chinese New Year. This was a few years ago. And at the Chinese New Year, they sent me a photo of them having drinks together. I didn't ask them to send me that photo, but it was nice that they were able to overcome that after the mediation. If they had gone to court, I don't think they would have. There are many things we can do, and sometimes we can have outcomes which, with all respect, which courts cannot fashion because courts are bound by precedent, by the pleadings. Whereas in mediation, we can be a lot more creative. I remember one very outstanding case where parties were fighting over money, a lot of money, and we're talking millions. And in the end, they agreed $12 million US. They could not agree on it, but they agreed to give it all to charity.
Wow.
And the 2 lawyers and myself, we sat down after and said, hey, today we did a good thing. Because the parties didn't really need the money. They already had a lot of money. But they were fighting over 12 million. And they said, all right, we'll give to charity, but we would give it to charities where we agree.
Wow.
And it was actually from an estate. And they said it will be in the memory of the dead person.
You made the live company relationship back again, everything real life.
Well, not every case you can do that. Let's be frank about it, honest about it. But maybe 1 out of 20 cases I can do something different and something a lot more creative and positive. So like in that case, that 12 million went to charities which help abused women, children, education. Not a bad outcome, right? Yeah.
So no bad memory?
Of course there are bad memories. Well, they're not really bad memories. It's just you feel disappointed when parties are sometimes so close. I do remember a number of cases where the offers put on the table, but people didn't accept. And then they go on to court. And after that, the lawyers will call me back and say, hey, we got less than what was offered. I said, yeah, you should have taken it. So you feel, maybe I should have done something stronger, something, to treat them. So sometimes you feel that we could have done more, but I suppose that's in every career or profession. You can't win it all. Yeah.
Thank you. Let's go to the next subject. Could you briefly introduce Singapore Convention and how did you take the initiative for establishment of the convention, and what's your view on going forward? Because now 55 countries executed, but still 10 countries ratified, and 2022 Kazakhstan is the only country ratified the Singapore Convention. What's your view on going on, and especially People's Republic of China, India, and US?
Okay, so for those of you who may not be that familiar with the convention, The Singapore Convention on Mediation is the equivalent of the New York Convention on for arbitration. So it allows enforceability of international commercial mediated settlements for countries who have ratified it. So I was involved in the discussions at UNCITRAL and for 4 years between 2014 and 2018. We were part of a working group, and it was very satisfying to see the working group come to a positive outcome, and which was adopted. And so it came into the signing ceremony was in 2019, came to force in 2020, September. So as you said rightly, 55 countries have signed it, 10 have ratified. 46 countries signed on the first day. That is a record. But I think the uptake has been a bit slower because of COVID, and also because of things happening in the world, like the war in Ukraine. So you need to get governments to put this on the national agenda. It's been very difficult because of COVID. But I'm quite confident that in the long term, people will come around because it helps. Why? It's giving business people an option. You already have it for arbitration. It's so simple to have it for mediation as well. So if there's a problem with enforcement, you go to the country, you go to the courts, and if you've satisfied all the requirements under the convention, then the courts will enforce it like an order of court.
Do you expect US and India and China will ratify this soon or later?
They will eventually. It's just a matter of time.
It's just a matter.
But I think US, China, they are preoccupied now. India too, the things happening in the world. So it's not been a good few years for the world really. COVID has been a dampener. Now because of all the problems arising from energy and supply chains. India, it has had a very strong impact in India because after India signed, they now are working on a mediation bill, and they are making use. Mediation is being used in India now, and before the convention, it was so difficult to get it going. And you've seen the change in Korea yourself, right?
Yes. Yeah,
and I've seen that change. 7, 8 years ago, when I went to Korea, people were not very interested in mediation. But
yes.
Today, all the large firms are interested because they know that parties are talking about it now, and this is another option. For me, it's a no-brainer as a lawyer. We should see ourselves as dispute resolution specialists, not as a litigator or an arbitrator or mediator. Do what is necessary to help the client resolve his or her dispute quickly, in the most cost-effective way. It will come around, and I'm quite confident.
All right, thank you. And next subject, SIMS and ICID had executed MOU on state investor disputes. SIMS has involved with many investor-state disputes regarding ICID mediation. And what do you see that there is any difference between ICID mediation and other commercial mediation? And if yes, what's the difference? And how many cases SIMS involved with state investor mediation?
You should know that there is a new working group at UNCITRAL, and they are talking about reforming the whole setup involving investor-state disputes. There is a lot of criticism about ICSID, about the process. I think they do their best, but there has been a lot of feedback that the current process needs to be improved. So I've been attending the sessions at UNCITRAL, and they are now looking at forming a multilateral permanent court to hear investor-state disputes and with an appellate division, which is very different from the current practice, which is just like arbitration. You create a tribunal and then arbitrators put their cases. So now we're talking about court. So whether it will happen, I don't know. There's still a lot of discussions going on, but it has attracted a lot of interest. So, but in the meantime, people are still using ICSID. SIMC, we have had an experience, and we are still a young body, but it was more of a ad hoc, bilateral kind of arrangement. It was not an ICSID mediation. But I think in Korea, it is quite a big issue, right?
Yeah, right.
Yeah. So there can be improvements, but I think people are working towards it.
So based on your experience,
investor-state actual mediation,
is there any practical difference between other commercial mediation?
There's a lot of difference. There's a lot of difference because there are many layers. It's not like company and party, 2 days you can resolve it, 3 days you can resolve it. So usually, whatever you decide has to go through other layers.
Mhm.
It could be other entities within government, for example.
Mhm.
So it usually takes longer. Usually takes a year or two. That's the difference. And the question of who has the power to decide. So that becomes important as well. Because if you have different ministries, for example, involved, who will take responsibility? What happens to the investment in the meantime?
I see. And does it take a year for a state investor
Yeah,
to
it can take a year. What I'm doing now is a year already. Yeah. It doesn't mean we meet for the whole year. We meet several times and you have to communicate, but it takes time for different agencies to consider the proposals. What I did, we had 3.5 days, we sat down, we came to an in-principle agreement, but it has to go through different agencies and then they come back with changes and then you have to rediscuss. I can't tell you the details, but it's challenging, but it's really useful because the outcome can impact countries, can impact citizens.
Let's go to your personal question. And as you are very successful as lawyers, a business world, you are one of the top successful businessmen in legal industry. So I think you have many tips to your juniors and other candidates for mediator or lawyers, attorneys, and law school students. I would like to ask some on your personal question about your experience. And I would like to ask first, what's your favorite failure you have ever made?
As a mediator?
No, just a lawyer.
Generally?
Yes, in general.
Not sure what you mean by failure.
I'm asking, you made a decision and you decided to do something and it turns out you regret a lot, but you could like that regret because you get a lot of lessons from the failure.
Okay.
So young guys need to have lessons from mistakes or failure. They don't have to afraid about failure and mistakes they make. So what I'm asking is, if you had made a big mistake, but it turns out very good, your valuable lessons to further your life or become your intangible assets for you.
Okay, as a mediator now, I've learned to look at things differently. I don't regard things as failure. So if even something doesn't turn out the way you expect it or you want it to happen, turn it around. I've learned to adapt that way. That's why when we did the training, I told you it's a life skill, mediation. Yes. It's like if you buy shares, for example, and then it goes down, forget it. Just cut it and move on. Don't spend time worrying or feeling bad about it. For me, that's just life. And look at the other positives. So I've learned to do it that way. I don't regard, life is like that. It changes and we adapt.
So you're saying that my question is wrong because there is no failure, right?
Yeah, that's how you define failure. But I think this is just life evolving.
Yes.
And things may not turn out as you hoped it would have, but actually there are other aspects to it. And you know that because when you get on and move on, you find that, yeah, that's fine. Do something else with my life. And I just I don't waste energy or time worrying or that, hey, I should have done it this way or that way. Maybe for a while, but just move on.
Oh, that's great tip for juniors. And that's what you have learned from mediator or before?
Yeah, so I tell young people today, my sons are in their 30s, that that's how you should look at life and just try and make the best of that situation and move on and not dwell on what you think it could have been.
Right.
And we learn that way.
As long as you can learn from something, there is no failure. I think that's your
right. Concept. And I tell parties at a mediation, there's no point looking at the past and saying it should have been this and that. Let's look at what it is today. But more important question, what do you want to do about it for the future? Which is something within your grasp, within your control. So an easy example is when we do, you are familiar with court work, litigation. When we go to court, we look at the past. We look at what happened 2 years ago or 3 years ago. The lawyers try to reconstruct the scenes, the events to the judge, and then you try and decide what happened in the past. So litigation is about looking backwards. Mediation is about looking forwards. Of course, what happened is important, but what's more important is the future. What do you want to do about it? Where do you see yourselves a year down the road? 2 years? You still want to be fighting? Husbands and wives, I tell them, you still want to be fighting when your son gets married, do you want to attend the wedding? You want to sit at the same table or a different table? Or you don't want to attend? Come on, when you have a granddaughter or grandchild, look ahead. So reconstruct your relationship so that it gets better, not worse.
That's great. Yeah. And in relationship to that, is there any habit that most improve your life as a professional?
Generally speaking,
yeah,
I think exercise.
What kind of exercise do you do?
I play tennis and I swim when I can. Social tennis, not the competitive. This morning I just went for a swim. So after a mediation, I take a break. I think we need pockets. I now have 2 granddaughters.
Wow.
So spending time with my grandchildren is very therapeutic.
Yes.
Yeah. Just play, just become a child for 2 hours. Just play, run around with them. It's very therapeutic.
Wow. Yeah, actually, she's my third daughter.
Yeah. Actually, I play music as well. I used to be in a school band. So I play the trumpet, the euphonium, and the tuba.
Wow, trumpet is quite difficult to play.
No, not difficult. Read, listen to music, watch Korean drama.
Korean drama. All right, thank you. And what's the best investment you have ever made other than Singapore convention? Either it's the money or time or energy.
The family is the best investment you can make. I had 2 sons. Actually, I wanted to have more children. But after my 2 sons, my wife said, "He's too tired." So I said, I wanted a daughter. And now I've got 2 granddaughters. So I think
wow. So
we are very blessed now. Family is most important.
2 granddaughters.
2 sons. Yeah.
Wow. So 5. And if you need to choose one, who will be?
You can't choose. You can't choose. Okay, don't try.
All right.
Be happy what you have got.
All right. That's the right answer. I asked a stupid question and you answer quite great.
No, it's not a stupid question. No question is stupid, DK. Yeah.
Another question is, if you can read just only one book for the rest of your life, what would it be other than the religious one?
Why do you ask this kind of questions, DK?
Sorry, pass.
Okay, because I'm mediation oriented, I'll tell people read Getting to Yes.
Getting to Yes.
By Roger Fisher. That book changed my life to a certain extent because when I did my course, I had to read that book. I wonder, have you read that book?
Yeah, a while ago.
It talks about interest-based negotiation. I did my mediation course. It helps you understand why things are why they are today. So you look at the Ukraine war, for example, you look at the interests of the parties involved. You look at Russia's interests, you look at Putin's interests, you look at Ukraine's interests, you look at the US, you look at NATO, you look at Turkey, you look at Israel. All the different actors, and they all have different interests. And when I did the session at Ozitron on the convention, it was the same thing. 50 countries formed a working group. Everybody says something, but they have their own interests. And if you can identify that, then you can find a solution. So in mediation, we look at parties' interests and we find solutions which match the interests of the parties. And Getting to Yes helps you to, yeah.
While listening your background and everything, I'm thinking about, do you have any plan to become a diplomat? Mediating country by countries, and there is a lot of interest, but mediator can mediate the country's conflicting interest. You have deal with companies.
But I think at that level, you need to have contacts at the international level in terms of governments and diplomats. I don't think I've got that at the moment. Maybe something which I can still learn and pick up. But there are many statesmen and women who can do that at the moment. For example, in the Ukraine war, Turkey has been mediating, Israel has been mediating. And some of the conflicts in the past, you have got people who are doing that, and they can. In Singapore, we have the famous ambassador, Tommy Koh. He has helped some of the conflicts in the past, international conflicts. I'm sure there are many people in the world.
Do you give them negotiating skills for diplomats in Singapore?
I don't, but I'm sure they all have their own sources. And they probably learn on the job, because when you are involved in international negotiations and you have to learn skills, it's different. It's different in a sense, but similar in many senses.
So you don't have any plan to go diplomat's word or a dream because you are still young, right?
I'm not young. I'm 66.
But young.
You are young.
Nowadays,
You are young. I'm not young.
60 is still
Young at heart. Young at heart. No, so I'm open when things happen and you see whether you can be of service, but I don't yearn to take things as they come.
Because you are specialized and you can identify the interest of the parties, and as you are skilled and you have a lot of experience in identifying their interest and matching their interest, I don't think that's quite different from country's interest as well. So you have very talented.
No, it's the same principle, but you need parties to respect you in that way and see that you have enough experience before they come and appoint you as a mediator. So there is a difference in that. You can have all the skills, but you need to be in a certain place. So that's why young people tell me they want to be mediators. I encourage it. And I say that if, for example, you're 32 years old, it's hard for someone to appoint you as a mediator. But if, for example, you have an expertise in a particular area, cryptocurrency, intellectual property, and you've written books, you might be there. So you need to do something above the skill, in addition to the skill. So that because people need to feel that, hey, somebody I can respect, somebody I think can add value. So I say you need to practice mediation, but you also need to offer something else.
Thank you. And another question is mediation advocacy, and that seems started to teach mediation advocacy as well. And now people are getting more knowledge on mediation advocacy, and I learned mediation advocacy as well. But in the real world, the well-trained mediation advocate is not, that. What's your view on the mediation advocacy as a full-time business other than mediator?
So it's a very important role, and a lot of lawyers don't realize that. They come to mediations, but key is this: how do you get the best deal for your client at a mediation? And you can only do that if you know how to prepare your clients and yourself. So I used to teach advocacy in court cases, litigation. And your system is probably different from mine. I mean, we follow the common law system versus civil law. But for example, I train young lawyers and I tell them, how do you prepare? First thing to do is you do your closing submission first. You prepare your closing submission. What are the 5 things you want to tell the judge at the end? Articulate that. Then, once you have your 5 things, then you work on your evidence. And in Singapore, we help parties write affidavits of evidence. So you write your evidence. If you don't have your evidence, you cannot justify your 5 points at the end. And then cross-examination, you have to defeat or you have to clarify some of the points which the other party has raised, but it must all lead to that 5 points. And then the last thing you prepare is your opening submission. So there is a method to how you prepare a court case. We talk about a case theory. That means what is the theory that you want to put forward to the court, to the judge, to tell him why he should decide in your favor. So this is advocacy. How do you persuade the court through evidence, through documents, through witnesses? It's the same way, the same thing in a mediation. Of course, the mediator doesn't act as a judge, but you use the same principles. So if you are a good advocate, mediation advocate, then I will say with my client, what is my target at the end of the mediation? So you could be claiming $10 million, but maybe for a mediation, I think if I can get $8 million in 2 days, it's a good investment, because to get my 10 million in court, I have to do 2 years or 3 years. So let's aim for that. And how do I reach that? So you need to decide when you write up your mediation statement, what goes into it? How do you prepare your client? Because the client speaks at a mediation. What is your opening offer? Your opening offer should not be your last offer. There should be some room for negotiation. What are other creative ways to solve it? So you need to prepare your client and yourself for the mediation. And how do you persuade the mediator? Okay, so a mediator cannot decide, but you can actually use the office of the mediator to convey messages to the other side. And we don't do it in an aggressive way. We do it in a persuasive way, which is mediation advocacy, which is different from court. So there is I run courses on this, and that's You need to help people understand that. And once the lawyer understands that, then he can prepare his client. Right now, people don't, well, some people do, but many lawyers don't prepare enough. Usually, they'll wait for like a week before the mediation, then they start getting things together. And that's not good enough. So
some of your description of a mediation advocate is more like negotiator and litigator, arbitrator, more like a kind of gladiator. I'm right. This position, this is legally right, and you are wrong. But a mediation advocate is a kind of negotiator, persuading.
Because you need the other side's agreement to the outcome. If you don't have that, you have nothing at the end.
So that's a little bit different from mediator and mediation advocate. It's more active negotiator.
Yeah, or like even when you don't have such a good case, you get the best of it for your client. Rather than make him go through 2 years and then lose the case and he pays everybody costs and loses all that time. So for me, that's how I would define the objective. So some people come to mediations knowing they don't have a good case, but salvage it. If you're a good lawyer, you salvage the case for your client. The client stays with you. You lose the case in court, the client leaves you.
So who will be candidate for good mediation advocate? And I think the transaction lawyers negotiate the contract, but litigation advocate or arbitration advocate is more like try to win and position oriented. So in my view, the transactional lawyer, a negotiator or financing documents negotiator are more like mediation advocate. What do you think about that?
No, I do think that the lawyers who are litigation advocates can become good mediation advocates. It's just learning something different and different skill set. But you raise an interesting point. Transactional lawyers can also play a part. And in the case I did, it's published in Global Arbitration Review, is the US $1 billion case involving an American and Korean company. The transactional lawyers were the ones negotiating, at least for one side. And proved to be very useful because transactional lawyers look for solutions. They're not there to fight. Sometimes we litigators tend to get in our own way because we want to prove a point. But transactional lawyers, they're the problem solver. You help the client solve the problem. So that's a useful. I think transactional lawyers actually should get involved in mediation. You're right.
Your case is POSCO versus Fuel Energy.
We can say that because it's published. That case, I learned so much from it. 3.5 days. But it's a demonstration to Korea that large cases can also be mediated successfully. That case, what we did was we created value to the case because the parties carried on a relationship which had been terminated. And more money came into it, but both sides gained in a different way. Mediation is making a good deal for your clients.
I was quite surprised to read the CEO, CFO of Fuel Cell Energies said thank you, publicly noticed their homepage about that mediation. And that mediation mentioned you. Quite surprised. Wow. Well, how thankful they make a public announcement for a mediation. I don't know the actual background, but it must be a quite good case. In that public notice, they said 5 ICC arbitration was mediated by you, just one mediation.
There were 5 arbitrations. They were not all ICC arbitrations. There were 5 arbitrations around the world. Singapore, Seoul, London, US. And there were 2 court cases in the US. But they've been fighting for years. So actually it reached a point, I think in a way, the arbitrations and the court cases helped. Because the parties reached a point where they said, look, we can't be fighting each other. Can you imagine a company, you have one court case enough to use up all your time, right? They had 7 adversarial processes going around the world. The time you spend just instructing your lawyers, preparing for the cases, is not productive for a company. And so I think the lawyers also realized that. That's why they told their clients, try to mediate this, to find an outcome which is better than having to spend the next 5 years fighting each other.
I think parties are very satisfied, but how about the arbitration lawyers? They lost their fee.
I don't think it's a loss. Really, I don't think it's a loss because remember I told you we all took an oath to act in our client's best interest, party's best interest. So I give you the example of a doctor. If I'm sick, I go to a doctor. The doctor cannot tell me, please carry on whatever disease you have for another 3 years just so that I can earn money. It's not ethical. If there's a way to heal me tomorrow, heal me tomorrow. You cannot carry on just because you want to earn fees or pay 5 lawyers' salaries on my fees. I think a lot of lawyers have ethics. We don't do that. If you have to fight, you have to fight. But if there's another way out for your clients, try it. And my argument always is, what's there to lose? You do a mediation, you can organize it within a couple of weeks. It takes 1 day, 2 days, 3 days. Even if you don't settle, you crystallize issues, you know your case better. What is the cost? But if you succeed, you save your clients so much. So I think we all have a duty to try. And even without formal mediation, I used to settle cases. Lawyers used to settle their cases. You speak to the other side, you pick up the phone, you talk. So it's part of our duty as a lawyer to help the clients and not just carry on. To be fair to the arbitrators, and I think they see their work that way. If you need my services, of course, I will be there and you pay me. But if you don't need it, so be it. It's not for me to hang on to your case so that I can squeeze from you. I think that's the wrong concept if you ask me.
I fully agree as a lawyer and as a mediation advocate. But if I were a lawyer and in the team of arbitration, and if my several cases are settled by one mediation, then I think I feel like something lost as a businessman, as their potential time fly away.
If you're good, you will get other cases. There are always other cases. I really beg to differ. I think we are there to be of service. If people need us, we are there, whichever role, arbitrator, litigator, mediator. If there's a service, I provide it, people pay me. But if people don't need the service, I can't force it down on them or try and delay it so that I can earn more fees. It's not right.
Then arbitrators should learn the mediating skill set.
I do something else. Yeah, you can be a mediator as well as an arbitrator. Why not? You're right. Offer different services, learn new ways to. Well, I think if you're good, you will get another case. Not to worry.
Thank you very much. My last question, is there any tip for lawyers in their 30s and all around the world?
Like you.
I'm 40. I want to be 30.
Why do you want to be 30? Good to be 40. Yeah. You face different challenges. So this is the main trend we see in the world today. If you are in the dispute resolution world, parties now use hybrid processes. They use mediation with litigation, mediation with arbitration, neutral evaluation, so different forms. So I think we should learn the different skill sets. Today, you want me to arbitrate? I can. It's my preference, that's all. You want me to really do a court case, I'll go back to that doing can. You want me to mediate, I can. And I offer that suite of services to clients. So for me, that is the trend for the future lawyer, to be able to offer the best services to clients, which help the clients resolve their disputes quickly and cost effectively.
That's great advice.
Yeah. Thank you. Then can all play the cello after that.
Come to my studio.
Come.
Thank you very much for your valuable lessons and your experiences.
It's been a pleasure. All right.
Thank you very much for your extra time.
Not at all. Thank you.
Thank you very much, George. Bye.
Okay. Bye.
Yes. Today, her name is Manon Schkanabilde. She is godmother of Dutch mediator, queen of online, offline mediation academy, and virtuoso negotiator. Hello, Manon. Welcome to the show.
Hello, DK. Thank you so much for this lovely introduction.
So you accept me?
Well, that's one of the things. So that's why we sat very early in my morning having this conversation.